Morning, everyone. Welcome to the Utah Supreme Court. We are here in the matter of State v. Blackwing. And before I ask for appearances, let me just thank counsel for your willingness to be flexible as to start time this morning. I greatly appreciate it. I know you both know the drill, but we assign 20 minutes aside. We routinely go over that. If we continue to ask questions, there's no need to ask if you can continue to answer. But if you see your time has expired and we have finished asking questions, we just ask you to please wrap up. If you're in your primary time and we go over, it does not cut into your rebuttal time. And then for those who might be watching here or online, just ask not to draw any inferences from the fact that we have more questions for one side than the other. It has no reflection on how we see the case. It's just where our questions are. So with that, if I could get counsel to state your appearances, please.
Christopher Bates for the state.
Good morning.
Good morning, Your Honors. Trevor Lee for Kane Blackwing.
Good morning. All right, let's begin.
May it please the court. The facts of this case are like something out of a movie. Two young women break into a home at night, dressed in black, armed with needles, saran wrap, a taser, and matches. A third waits off-site. Their plan is to murder a teenage girl and her family so that they can't testify against the man that the women live with. Thankfully, the plan fails and the women are arrested. The state has charged the ringleader of the plot, Mr. Blackwing, with conspiracy, solicitation, and attempted aggravated murder. To convict, the state will need to persuade the jury that the three young women tried to murder a teenage girl and her family, one of the most heinous offenses imaginable for him. That means the state is going to have to tell a story. It's going to have to explain how the women met with Mr. Blackwing, how he drew them into his web, how he groomed them and prepared them so that when the time came for him to ask them to do something unconscionable, something utterly abhorrent, they agreed. The story of their relationship and the story of why Mr. Blackwing wanted the teenage girl and her family killed are integral, essential aspects of the state's case. They are intrinsic to the charges against Mr. Blackwing. They serve multiple non-character purposes, and they carry undeniable probative value. The district court abused its discretion in excluding virtually all of this relevant, highly probative evidence which bears directly on the charged crimes. This court should reverse.
Can I ask you a question about what exactly the state is trying to admit in that second group of evidence regarding Tina? As I understand the state's brief, your interest is in telling the story and showing the jury how he came to have control over her. How is that different than what you're trying to admit in that third group of evidence?
I think they are closely related, Your Honor. I think that, at least as the district court looked at it, and I think because of that, how we laid it out in our brief, that second group we talk more about Tina, the third group talk perhaps more about Raven and Teresa, but I think that analytically they really are the same because the evidence from Tina's case is how Mr. Blackwing drew Tina into his web, how he and the other members of the household introduced Tina to the relationship dynamics, how he had total and complete control, how he overcame her will, how she came to basically do everything that he asked. That really is the same sorts of things that third bucket of evidence shows. So I don't know that analytically there's a real distinction there. Okay. Now, with regard to Tina's case, that did ultimately culminate in the sexual coercion of Tina. And we think that that is plainly relevant, probative, and intrinsic as well because that shows really the extent of his domination and control over Tina and also over Raven and Teresa as well, because they also participated in the process of enticing and coercing her to join the household, inculcating her in the relationship dynamics, his spiritual theories and so forth. They told her they wanted her to join the family, they gave her gifts. When she did join the household, they told her about what sorts of sexual acts Mr. Blackwing liked. So they participated in that process as well, which both shows again, their participation, but also the degree of domination and control that Mr. Blackwing had over them as well, because they were willing to basically facilitate this underage rape that happened.
That makes sense to me. So just to be clear, the state doesn't want to admit evidence that he was actually charged with sex crimes or convicted of them, just what actually happened. Is that right?
So the actual conviction, I think, is relevant because it shows the strength of the evidence supporting that. Now, that specific thing I don't think is as essential or perhaps is super essential to the state's case. I think it does fit relevance, probative value, intrinsic, because it does show the strength of the state's evidence. But you can also get most of the way there if you're just telling the story about how she came in, what ultimately happened, without actually admitting the fact of the conviction. But I do still think it does satisfy those three aspects.
Do you think, however, I understand your argument that excluding the nature or anything about this was an abuse of discretion, but do you think that the district court might have discretion under 403 to determine that the fact that he was actually convicted might be more prejudicial or run the risk of confusing the jury? In other words, if you prevail in this appeal and this case goes to trial, will the district court still be able to parse the evidence as it comes in at trial and decide whether a particular piece of evidence, whether the prejudicial effect is going to substantially outweigh the probative value?
So that'll probably depend in part on how this court writes its decision. If this court reverses the analysis the court sets forth in terms of what's relevant, what's probative, I imagine the district court will need to take into account what this court says in deciding that. And so I think the question will be, if this court reverses for the district court, what evidence falls within the guidelines that this court sets forth in its opinion.
Do you think that, some of the evidence, right, about the specific pieces of evidence about the specific acts, I'm not sure that the district court or this court knows what evidence that's going to be. It seems like it was more just a categorical ruling by the district court that category of evidence was inadmissible. Do you think that we can give more specific guidance on what would be admissible under 403 and what wouldn't be?
Well, I think the court can certainly look at the notice of intrinsic evidence, the statement of facts that the state put in its opposition to the motion in limine. This court also outlined some facts in its order. It did reference some specific things, such as how the women were required to call Mr. Blackwing my lord, how he had control over all important decisions in the household, how if they disobeyed him, there was a process of apology and restitution, how they were told that if they betrayed him, they would be punished and possibly killed. I think there were a couple other small facts that the district court mentioned. The district court drew those from the notice of intrinsic evidence and the state's statement of facts and the opposition to the motion in limine. So I think the court can look at what the state put in those filings to understand what sorts of particular acts the state would be looking to introduce.
So you do want this court then to if we were to disagree that if we were to conclude that the district court's order was too broad, you would want us to go through and look at each of those individual pieces of evidence, or are you just asking us to find that the district court's ruling in this case was an abuse of discretion and these issues can be raised at trial if appropriate?
I think what would be most useful for the court to, obviously the court can do what it thinks makes most sense on that front, but I think what would be most useful with the court at least to look at what the state identified in its filings, what the district court identified in its order, and at least as to those instances provide guidance about where those fall on the line. And I think that also would be helpful for the district court in the event that there were other specific facts the state sought to introduce. The district court would have the benefit of this court's analysis on those issues in deciding how to handle those questions.
Can I ask one follow-up question about the conviction regarding Tina? Is there anything specific about the conviction that he was charged and convicted that is part of the narrative that you want to get in about his domination?
So if we're talking solely about the fact of conviction as distinguished from the underlying facts, again, I think that the relevance, probative value there is that just shows the strength of the evidence supporting those claims or those charges. As to the underlying facts, Tina was a high schooler. Mr. Blackwing enticed her, coerced her to leave her family to move in with him He's about 30 years older than she is. So he basically groomed and coerced her to agree to have sex with a man 30 years older, her father. That goes to show the extreme degree of domination and control that he had over both her and over the other women in the household. So I do think the fact that this was a process that then culminated in her agreeing to do that and in the other women facilitating that act, that I think is relevant to the story the state needs to tell, because again, the state is going to have to persuade the jury that this man convinced these three women to agree to murder a teenage girl and her family, a tremendously heinous offense. The jury is going to wonder, why on earth would these women have agreed to do that? And so that story of how he came to exercise such domination control and the extreme degree that he had, I think is plainly fits those buckets for that.
I
those
don't know
questions.
if these facts are before us, but I'm curious if she, although she was coerced and underage, if she sort of stayed with him through that prosecution, is that part of the story?
So certainly, her staying with him after he did, committed crimes and so forth, I think, her coming in, her staying, that all goes to show his degree of domination and control that he had over her. Now, just looking at the timeline here, so Tina's rapes actually happened contemporaneously about the same time as Catherine's rape. They were both in March of 2014. It was a few months later that Mr. Blackwing was arrested and charged with Catherine's rape and so was incarcerated. So it was only it would only been a period of a few months after Tina's rape before Mr. Blackwing was incarcerated and so no longer was in the household. But I think, I think what Your Honor is getting at, the fact that she stayed with him, after he committed certain crimes, after he engaged in certain heinous acts, again, I think goes to his degree of domination and control that he had over her.
Did she participate in the prosecution, Tina?
Of
the charge against him based on
against Tina
the
or
rape of
against
her.
or against Catherine?
I guess I'll be more clear. Did Tina participate in the prosecution of the charges against him for raping Tina?
So I don't know that is in the record here. I have to presume that she did, that she testified against him to establish the facts in that case. I don't think that information is in the record here. There was a court of appeals decision that came out of that prosecution. Maybe there'd be something in that decision about that. But I would have to think that she did testify against him in the case against her, which happened after he was arrested in this case.
So I think that this second bucket is the toughest one. And whether the actual fact of conviction is something that is necessary or might go over the line, the 403 line is the toughest question. But I guess it would depend on whether it's part of the narrative, that if there's any narrative reason that needs to come in, like during, the story of how she was enticed into doing this and coerced, and then maybe participated or refused to participate in the prosecution, but still stayed with him even. If there were some reason that's relevant, that might give it more probative force, but we don't really have that in front of us.
In terms of how she participated in the prosecution
Just
against him.
the mere fact that he was convicted of something, I could see having less narrative force. It does show that those allegations are credible. I don't know what witness this would come in through, if Tina will be a witness or not. But it seems like without knowing beyond that what the narrative force is of the actual conviction and that prosecution, it's hard to know how much probative value to give that evidence in the second bucket.
I understand, and I do think, as I mentioned earlier, even if the court concludes that as to the fact of the conviction itself, that necessarily doesn't meet the standard, I think that the underlying facts of that conviction are certainly part of the narrative, that he enticed, coerced her, she agreed to have sex with him, submit to that underage
Can I
rape.
ask one follow-up on that? I'll tell you what I'm concerned about with the conviction is exactly actually what you said, that the jury in this case would find that those allegations were credible. And so I worry that they'll give too much weight to it, right? Rather than acting as independent fact finders about whether this behavior actually occurred. Am I right to be concerned about that, or is that concern misplaced in your mind?
So if we're thinking about unfair prejudice here,
Right.
Your Honor, Mr. Blackwing has been charged with attempted aggravated murder, conspiracy, solicitation, probably one of the most heinous offenses one can think of. I think it's pretty clear from the case law that when we're evaluating unfair prejudice, one of the things that the court takes into account is the seriousness or egregiousness of the crime with which the defendant has been charged, comparing that with the prior acts or other acts or whatever term that you use there. Yes, it is a conviction. Yes, it is for underage rape, but it is not nearly as egregious as what we're talking about here, a conspiracy to murder a young woman and her family. So, and it's also so egregious. And then another factor that's identified in the case law is if it's a distinct act. So if the prior act is the same thing for which the defendant's been charged, so if the defendant's up on charges for sexual assault, the prior act is a sexual assault, that again can go towards unfair prejudice because there might be some worry that the jury might confuse the two or might draw an improper inference based on the fact that he did the exact same thing in the past with what he's charged here. Again, these are distinct offenses as well.
But just help me here with this. I mean, usually when we bring in an other act, and I understand here you're saying that the other acts against Tina aren't other acts, they're intrinsic. But it's the other acts that are probative, not usually the fact of the prior conviction. And that's the other problem I kind of have here. I understand your argument about why this process of control and manipulation and indoctrination is intrinsic, but I don't see how the conviction is. Then again, I'm not sure if 404B necessarily applies to the conviction or just the underlying conduct that the conviction represents. So I'm just trying to figure out how the conviction itself fits into this whole analysis.
Again, Your Honor, I think it's because it shows the credibility or the strength of evidence that was supporting those underlying facts. If this court, has discomfort with the fact of introducing the conviction, I think that the state can get quite some distance to telling that part of the narrative by introducing the underlying facts without actually getting to the conviction. So, again, I think that the conviction does qualify, but if this court has discomfort with going there, I think the underlying facts go most of that. Okay?
Counsel, I would guess you assume the defendant's principal defense will be that these women acted on their own initiative without direction from him. If that's the case, would it be fair to say that the more compelling his case for independent action, the greater the need for each of the three categories of evidence that we're discussing here?
I think it is the case that assuming that Mr. Blackwing comes in and his defense is that the women acted on their own initiative, I think that even heightens the relevance and the probative value. It certainly goes to a non-character purpose under 404B to rebut a defense that they acted on their own initiative. But I think even setting that aside, when the state is presenting its case in chief here, again, the jury is going to have, I think, a deep question about why on earth would these women have agreed to commit such a heinous act. And so in its case in chief, this state is going to need to introduce this evidence so it can tell this narrative to explain to the jury why the women, separate and apart from the question of a likely defense that they acted on their own initiative, why on earth they would have agreed to enter into this scheme, to enter into this conspiracy.
Has he suggested other defenses?
I don't recall anything in the record where he has suggested other defenses.
And might there evidence of their level of commitment to him, respect for him, on the other hand, suggest that they could well have acted on their own initiative to protect him, absent any direction from him? Can it cut that way as well?
Certainly that's an argument that Mr. Blackwing could raise. I think that were he to do so, I think that would only highlight the relevance and the probative value and the intrinsic nature of the evidence that we're talking about here, because what this evidence shows is that not only did they follow these relationship dynamics, not only did they do whatever he said, call him my lord, etc., because of their affection for him, but that they did so out of fear as well, that they feared him, and that he had such domination and control over them. So in other words, it's, yes, you know, if they were to be put on the stand and asked if they loved him, well, you know, maybe not now, but at the time they probably all would say that they loved him. But that's not the only thing that was going on here. It wasn't just affection for him. It was fear and the fact that he had, you know, I don't know what the right term is, inculcated them, groomed them, had created this and gotten them to accede to the situation in their home where he made all important decisions, where no even, you know, minor decisions weren't made without his input and without his agreement. So it wasn't just, you know, they loved him and had affection. It was, there was fear, and he has such domination and control that he basically made all decisions in the home.
Looks like there are no questions pending. Thank you.
Thank you.
Good morning, Your Honors. Trevor Lee on behalf of Kane Blackwing. I think I'm happy to go wherever you guys would like, but maybe I'll just kind of pick up on some of the points we left off on with Mr. Bates's argument. You know, Justice Hagan, I think you asked something to the effect of, look, is this too broad a ruling? Is this a categorical ruling? And I think what you have to remember here is that's what the state requested. The first argument in Blackwing's motion was, these notices are improper. We don't know what you're trying to introduce. You're just saying we want these entire cases. And so what the district court did when it started the hearing is it said, okay, let's start with the state. State, what is it that you want here? And what the state said is, this is record 663. They said, the court said, do you want to get into the underlying facts pertaining to each of these convictions? And the state said yes. And further on in the hearing, the court said, look, you're still not really giving me anything here. You're telling me you want everything in the entire case, including all the underlying facts. And what the state said was, look to our notices in our opposition brief. So
Can
really,
I
what the state
interrupt you there? I was under the impression, I mean, the state gave notice of their intent to admit this evidence, but I was under the impression this was the defense's motion in limine to exclude.
It was, Your Honor, yes.
So the state didn't move in limine to admit particular pieces of evidence.
Yeah, and sorry if I misstated that. I think under 404B, it is the state's obligation to give notice, and I think the point here is that the notice was extraordinarily broad. We're introducing these entire cases. So what you see in the district court's ruling is trying to parse out, okay, what from these cases can I let in and what can I take out without, frankly, much help from the state in terms of specifics in terms of what they want in.
And on the third category, the court ultimately held that evidence could come in of the patriarchal controlling nature of the defendant, but no underlying details, such as my lord and I killed thousands and so forth. How would that evidence actually be presented without providing detail?
I think the way it would be presented, Your Honor, is primarily through Tina, who's a cooperating witness at this point in this case. And you know, I think this gets to the notion that you asked about in the opening, which is whether they acted on their own and whether that's going to be a defense in this case. And I think you need to remember what evidence is going to come in. You're going to have 11 weeks worth of jail recordings of Mr. Blackwing instructing these women to do this. Now, again, it was in the context of a video game. So, but you have him instructing them to do things. You're going to have Tina saying he was instructing us to go in and murder Catherine. You're also going to have Tina, to your point, saying, look, he was manipulative. I was in a romantic relationship with him. He was controlling. Now, she can't say, well, he required me to call him Lord. She can't say he told me that he's killed thousands of people. There are a few discrete things that the district court listed out that she can't say, but she can give general background information. And then you're going to have evidence that Tina and Teresa did go forward with this plan that Blackwing allegedly instructed them to do and broke into the home. So I think that the answer is the evidence is probably primarily going to come in through Tina.
Did you argue below as to any of the evidence that it was cumulative? That it was cumulative. It sounds like that kind of argument at some point.
I didn't catch the first part of the question, Your Honor. Did you?
Did you argue below, or is that a question for us? Whether
I don't think it was argued below, Your Honor. But one thing that this court has said in Verde is, one of the roles of the court in a 404B inquiry is to kind of look at the proper purpose. Now, we're not weighing the proper purpose versus an improper purpose. That's for 403. But the court did say one of the roles is for district courts to look at the alleged proper purpose and say, is this actually a proper purpose? And is the evidence actually supporting this proper purpose? And to the first point, one of the examples that either Verde or Thornton gave, I forget which one was, I think it was Verde, said if the evidence is that the state is offering, that's the bad act evidence, if that's cumulative, that is an indication that it's not a proper purpose, even if it were otherwise going to prove an element of the crime. So I don't know offhand, Your Honor, if that was argued below. I'm not counsel below, but I think it is something that this court can consider in the 404B.
That
analysis.
argument does assume that 404B applies here. Can we talk a little bit about that? I understand your argument about intrinsic versus extrinsic, but let's assume that this court were to find that that is just a reflection of the rule, right? The rule talks about other acts, and so we first have to decide whether this is actually another act instead of part of the crime. What's your best argument that this is not, I like to say, integral to the crime itself, where he is charged with solicitation to commit murder and conspiracy?
Which evidence, Your Honor?
The evidence that he was manipulating and coercing these women.
I think the argument is that manipulation and coercion aren't at issue in any of these crimes. You've got solicitation, which requires an agreement, conspiracy, which requires an agreement, and solicitation, which just requires asking, frankly.
And
So-
why wouldn't the state be entitled to present evidence of why these women would agree to do such a thing?
Well, I think that the state can, Your Honor. It just can't do so through specific acts. It can't say, for example, with Tina, it can't say, well, Tina, wasn't Mr. Blackwing convicted of raping and sodomizing you? And I think on that point, a lot of this evidence doesn't even get to the point of coercion and manipulation. I don't think that there's a strong argument that the fact that Blackwing raped and sodomized Tina in the past means he coerced or manipulated her in this case. I think the stronger argument there that the state is entitled to use is evidence from Tina. Yes, he was very coercive. Yes, he was manipulative. And I understand the state's point on this point, which is, well, it would be better if we could get into the details. And I think what the cases say on this point is sometimes with Rule 404B, we understand that it would be stronger with the details, but we're excluding them anyway for character reasons.
But you recognize, I'm sure, that I think the primary case is Old Chief from the U.S. Supreme Court, that the state is entitled to put on more than just the bare bones of a case that meets the elements, that they're entitled to the narrative force of their evidence. I mean, where do we draw that line?
So I think where you draw that line, Your Honor, is the same way that Verde did. Verde looked at Old Chief and it said, okay, yes, the state is allowed to not accept. In that case, there was an offer to consent to the intent element, and the state rejected that offer and wanted to put on a bunch of evidence to that effect. And what the court said is, okay, look, you're allowed to reject the state's proffer here or offer, but it's going to come back, and we're going to be able to take that into consideration in 404B. The fact that you want to bring in evidence that might otherwise not be at issue, that might otherwise be cumulative, is not going to be a get-out-of-jail-free card for 404B.
Well, why isn't that more properly thought of as a 403 inquiry rather than a 404B inquiry?
I think it is, Your Honor. I think generally when you're balancing, it is. But this court's previous case law does say that there's a preliminary inquiry of whether the proffered reason is actually a legitimate reason or whether it's pretext. Again, I think it's kind of a preliminary inquiry, and then most of the work is done in 403 to say, okay, fine, you have this legitimate reason. We're going to concede it's legitimate. You have this character reason. Let's balance the two. That happens in 403.
But before we even get to whether it's a proper purpose under 404B, we have to decide if 404B applies. What's your best argument that this evidence, and let's treat the Tina evidence and the other manipulation evidence together, and then separately we can talk about what the nature of the charges were in this particular case. What's your best argument that those are not just part of the narrative of this crime?
So I think it may help, two quick points about 404B. You mentioned the other acts or other acts language. That is the reason that federal courts have kind of gravitated toward this intrinsic exception, inextricably intertwined. And I think it's worth noting that Utah's language is not the same on that point. The federal rule says other crimes, wrongs, or acts, and Utah's language is crimes, wrongs, or other acts. And I think probably, now, we're not writing on a clean slate here. There's been much said about this already, but I think probably the most natural reading of Utah's rule is acts other than crimes or wrongs, not necessarily acts other than the acts in this case. And I think that makes sense, because what Rule 404B is doing is it's talking about proper purpose versus not proper purpose. It's not talking about inside the case versus outside the case, which is the work that federal courts are using the word other to do. So I think if you're looking for an exception, and we made the argument initially there probably should be no exception, we should just use the rule language. I think this is consistent with this court's statement in Green, getting rid of the doctrine of chances, where it said, look, let's just look to the rule language. But putting that aside.
But wait a minute, sorry.
Sure.
If we read the rule that way, that it doesn't require, it's other acts, but wrongs and crimes is within the rule, doesn't that mean that even direct evidence of the crimes charged is subject to 404B?
Yes, and I think that is the clearest exception, I think. That's one area where I think you could have an exception. Now, as I said, Verdi said that even evidence of the charged crime might not be a proper purpose if it's a conceded element or if it's duplicative. But you're right, Your Honor. I think 99% of the time, evidence of the crime charged will have a proper purpose. And that's why our proposed rule has that as the first bucket. It's evidence that's necessary to prove the crime charged.
But 404B doesn't even talk about proving the elements of the crime. I mean, if we read 404B the way that you're suggesting, that any crime or wrong has to go through a 404B analysis, I mean, that would be a major, that means every piece of evidence, essentially, that's inculpatory would have to go through 404B. Is that, do you think that's the right reading of the rule?
I think conceptually and theoretically it is the right reading of the rule. I think the rule says even evidence that, what 404B is excluding is evidence used for character purposes. And I think if you're using evidence that proves the crime for a character purpose, I think it's excluded under 404B. But I get the practical point that, 404B has other implications. Notice, jury instruction. And so I think that a middle ground may be exempting any evidence that is proving the crime charged.
Well, then doesn't that just sort of, doesn't that become circular though? Because then the question is this evidence of the crime charged or is it not? And when we have a solicitation and a conspiracy case, why wouldn't the relationship among the alleged co-conspirators prove the crime charged?
Yeah,
whether there was an agreement or whether he commanded or induced someone to commit a crime.
Yeah. So in the framing, I think I misspoke. The framing that we propose is necessary to prove the case, and this is quick aside, this is kind of the framing the Third Circuit, the Seventh Circuit, and the DC Circuit have settled on after kind of wrestling with the inextricably intertwined. But I do think that conspiracy cases are going to let more evidence in because I think there's going to be more evidence necessary to prove the crime. In this case, I just don't think that, well, the argument is twofold, I think. I don't think that the state needs to prove that Blackwing manipulated these women in order to prove the crime. And I don't think that the details of Catherine's rape show that he manipulated them, or the details of Tina's rape and sodomy show that he was later able to manipulate them.
But why can't we protect against that by having the district court decide where the line is at trial, depending on what comes in? Because it seems to me that at least what the state is saying in their briefs is that they don't want to admit a blow-by-blow of these things, that what they're trying to do is establish, one, what the nature of the crime charged, to show that he had a motive to silence her, and that they want the nature of the entire relationship with Tina to show why she would agree to do such a thing at his request. If they start getting into the details of the actual rape and all of that, isn't that just an appropriate time to object at trial under 404 and let the district court rule on that on a case-by-case basis?
I think so, Your Honor, and I think part of the problem here is the arguments on appeal now are different than the arguments that were placed before the district court. To your second point about Tina, not as much about Tina, but I think, the state is entitled to ask Tina about her background and the background dynamics with Blackwing and the fact that he was manipulative, that he was coercive. The part about Catherine, I know the state is saying now it's not asking for a blow-by-blow, but in the three pieces of, the three briefs that it put before the district court, it was asking for that, and then it doubled down on that in the hearing, where the court said, "You really want the facts of these cases?" And the state said, "Yes, we do, and here's where we lay them out in our opposition." So I understand the state's point now. The sentence is relevant. I think it probably is. Now, maybe there's a 403 issue there. I don't know, that hasn't been briefed. But I think for 404B purposes, yes, the sentence is relevant. I think the problem is they just didn't get that far down the path with the district court, even though the district court was kind of inviting it. The argument was just never made. So, we frame it as a preservation problem. It's almost slightly different. It's that they're asking for different relief at this point, right? They're asking below to get in the rape details, and they're asking here to get in the sentence.
To follow up on Justice Hagan's question, and an earlier question I asked, wouldn't it be the case that the trial, the importance of these three categories of evidence might vary depending on the strength of the defendant's case, especially any argument that the women acted on their own initiative? And given the fact that it could well be in flux in that sense, would it make more sense to allow the court to make that determination based on the evidence actually before it?
Yes, I think it could, Your Honor, especially maybe the third bucket of evidence where it's a little bit more amorphous, what's being asked. I candidly don't think there's any universe where the rape details of Catherine are going to be relevant to any element at trial, and I don't think that there's any universe where the convictions for raping and sodomizing Tina are going to have any relevance at trial. So I think it was a legitimate move by counsel below to try to get those excluded at this point. But I agree with your point that some of this evidence, maybe the boundary of where general relationship dynamics veers into improper specifics, is probably a case-by-case issue. And I think what the district court did is try to draw a preliminary line, and maybe that needs to be revisited at trial. But I guess my larger point is I think most of what the district court excluded, there's not going to be any universe in which it's relevant.
Can I ask you to elaborate a little bit on specific things that you think would be over the line in terms of 403. So I think in answering the chief's question, you said the rape details of Catherine, and then the conviction regarding Tina. In terms of the bucket 3, are there specific things? So I think right now the line drawn by the district court is basically the state can get in, generally he's coercive, he's manipulative, but not specific details of how he is. Are there specific details that you think you would highlight as being over the line for 403?
Yes, I think that the statements, and let me preface this by saying this third bucket wasn't really a bucket in the notices. It was kind of just off-the-cuff statements in the notices, and then it kind of morphed into its own bucket in the order. So it hasn't been fully fleshed out, but the district court mentioned a couple things, that he's killed thousands of people. Okay, maybe that becomes relevant in some way at trial, but I think that's fairly prejudicial in a murder hearing. That he made them call him my lord. Again, I think that a lot of these get to this idea that he's controlling them, and I just don't think the state needs to prove that to prove solicitation or conspiracy. And to the extent it does, I think they have this background evidence. They have Tina's cooperating testimony. They have the 11 weeks of recordings. But to get back to your question, I'm trying to remember offhand exactly what the court excluded, but calling him my lord, killing thousands of people.
Would kill them.
Excuse me?
Would kill them.
Yeah, that he would kill them if they didn't do what he said. Again, now if it comes down to it at trial, that it's really coming down to whether they agreed to follow his orders or not, maybe that gets revisited, but I just don't think that's, given the elements at issue, I just don't think that is going to be at issue at trial.
Would it be less prejudicial, so if it's relevant that the reason the women went along with it is because they were scared of him, is it relevant or is it probative to say he told us he'd kill us if we disobeyed him, and we believed him because he told us he'd killed other people?
I don't think so, Your
without
Honor.
the thousands.
Yeah.
Which would be surprising if that's true.
Right, yeah. Impressive.
Yeah.
I don't think it is, because I don't think the state needs to show why they agreed. They just need to show that they agreed. And frankly, with solicitation, it's even easier. They just have to show that he asked. And as far as showing why, or showing that they agreed, I think that the jail recordings, Tina's testimony, and the fact that they actually did it is going to be sufficient there.
But doesn't the why help a jury understand, or doesn't the why help the jury find someone's testimony credible? I mean, it's one thing for someone to say he was controlling, but without any detail, without any explanation of how that came about or why that was so, a jury might think, I don't know if I believe that. Isn't it in the details that
Yes.
lend to credibility, and so that's why it's important?
I think, yes, I think so. I think it may add to relevance, and I think, we just need to remember the other evidence they have, which is Blackwing's own recorded statements and the fact that they actually did it.
As to Catherine's sexual assault, if the defendant had perceived that case, the state's case, to be a flimsy case, he has less motive to take action. Is that fair?
Yes.
So shouldn't the state be allowed to emphasize the strength of that case to kind of highlight the depth of his desire the depth of his motive?
In theory, yes. That was not argued below, and that's probably why the district court didn't address it below. And I don't think that the details of how he raped her show the strength. Maybe something to the effect of, look, there was this one witness, there were two other people who were going to testify about it. This is what the sentence was going to be. These are all things that haven't been explored because they just weren't argued below. But yes, the answer is yes.
One question about the second bucket, the evidence about Tina, and not necessarily the conviction, but the underlying facts about the sexual assault of her. I assume that if she's the cooperating witness, there will probably be cross-examination challenging her version and maybe even saying she's lying about it because she's trying to get out of responsibility. And so the relationship between the other two who are not cooperating and her might become relevant. Is if the underlying details are that the other two women helped groom her, helped bring her into this situation, could that become relevant when her credibility is attacked maybe by the other two?
Relevant to showing.
Well, let's say that, let's say one of the other two women testifies on behalf of Mr. Blackwing and says she's lying. The fact that those women also, their role in bringing her into the situation, would that be probative?
I suppose it could. I don't know if that means you need to get into what Blackwing is trying to exclude, which is the fact that he raped and sodomized her and the convictions.
Yeah.
But yeah, in theory.
But maybe the
yeah.
overall dynamic, but some specific details make it over that 403 line.
Yeah, I agree, yeah.
Okay.
One more question about the Tina item. You've conceded, and I think properly so, that the fact that he was facing a very serious criminal charge that might have a hefty sentence would be relevant to show his motive to commit the charged crimes. Does the fact that he was previously convicted for doing for similar acts with Tina, does that affect what kind of peril he was facing in the underlying case involving Catherine?
You know, that's a good question, Your Honor. I don't know. It's not in the record. It wasn't a justification argued below for getting Tina's convictions in, but yeah, I guess I just don't know.
Okay, thank you.
Thank you very much, Mr. Bates.
My colleague made a textual argument about Rule 404B, pointing out some slight textual differences between the Utah rule and the state rule. I don't have them in front of me, but I believe that the advisory committee notes to Utah's rule say that the Utah rule was initially adopted verbatim from the federal rule, and that further changes were intended to be stylistic. We actually had a line about this in our original reply brief. We took it out in our replacement brief, but I believe that the advisory committee notes have language to that effect. As to Catherine's rape, and whether the underlying facts or the details, however we want to describe them, their relevance and their probative value. Obviously, the seriousness of the charges against Mr. Blackwing are plainly relevant and probative here. The more serious the charges he was facing, the stronger that his motive would be. But even as to the underlying facts, of course, we disagree with Mr. Blackwing's characterization that we're seeking to introduce a blow-by-blow narrative. At oral argument below, the prosecutor said that we're just looking to get in the basic facts. I think things such as Catherine is Mr. Blackwing's niece, that she was over at his house for a birthday party, that she wanted to sleep in the room with her siblings, but he had her sleep in the room with him, that she was the only person in the room, that during the night he forced himself on her and had intercourse, that she told her parents, that her parents then told the police. I think those are the basic facts that what the state needs to introduce here, because that both will establish the nature of the charges against him, that it was rape. Obviously, that's relevant to motive. Explains why Catherine was such a crucial witness. So the district court allowed in that she was the sole witness. Okay, that goes some distance there, but if what we're talking about here is a rape and she was the only person in the room, that really does establish how central of a witness that she was. And then also the fact that she reported to her parents and then her parents reported to police, that connects the dots for the jury of why Mr. Blackwing would have wanted her family sentenced as well. So I think that that's what the state would need to introduce there, and I think that those basic facts do show each of those points. My colleague also argued that manipulation and coercion are not at issue, in this case not at issue in the crimes. But again, the jury is going to wonder why the women would have agreed to commit aggravated murder. The state's going to have to persuade the jury that the women agreed to commit aggravated murder. And so, yes, it may not be an element, but as part of the state putting on its case, persuading the jury of those points, the state is going to have to persuade the jury that they agreed to do it. And there was some discussion when my colleague was at the podium. This court allowed testimony, general testimony that he was manipulative, coercive. That's very different from testimony about, the concrete evidence of their relationship dynamics. How it was that he was manipulative and coercive, the degree of domination and control that he had over the women. And one other point that I failed to mention when I was just discussing Catherine's case now, as to the intrinsic nature there, it was a necessary lead up. This case would not hopefully have happened had there not been Catherine's case, but also it's an element of the charge offense, right? One of the aggravators that the state charged for aggravated murder was that that it was for the purpose of preventing a witness from testifying, interfering with a legal proceeding. So that's on the aggravated murder charge, on the conspiracy and the solicitation charges as well. Those charges depend on what the intended crime was. The offense level of the conspiracy and solicitation crimes depend on the offense level of the intended crime. Under Apprendi, the state has to introduce evidence of what that intended crime was. So that is further reason why Catherine's case is intrinsic.
Do you know the answer to my question about whether the conviction in the case involving Tina exposed him to greater penalties in the rape case involving Catherine?
The information, so I don't believe that the information in Catherine's case referenced the prior conviction of Tina. So at least in the initial charges, I don't believe that the state pointed to the evidence, the conviction in Tina's case as a reason for a heightened sentence. That may be because of the chronology. The charges in Catherine's case may actually have come before the charges in Tina's case. But at least the information itself, I don't think, points to the conviction in Tina's case as reason for an enhancement. And we haven't briefed the question. So if Mr. Blackwing is convicted in this case, or if Mr. Blackwing were to have been convicted in Catherine's case, he actually ultimately pled out in Catherine's case to forcible sexual abuse.
Okay.
And I don't know offhand, I don't think it's in the record if his sentence in Catherine's case was enhanced because of his conviction in Tina's case.
When did the conviction in Tina's case come relative to the alleged plot to murder Catherine?
So the plot against Catherine was hatched in July of 2014. Let's see here. So Mr. Blackwing was charged in Tina's case in July of 2015. I don't have in my notes when the conviction happened in Tina's case.
So the plot to commit the murder happened before he was even charged with Tina's rape. Is that what you're saying?
Yes, that's correct.
Okay.
I did not realize that. Okay, that then takes care of my question.
Okay.
So,
Okay.
I have one quick
Yes.
question. How old are these women now, the three of them?
Tina was born in 1996, so she would be almost 30 years old. Raven and Mr. Blackwing, just parenthetically, was born in 1969, so he's almost 30 years older than Tina is. Raven and Teresa are older than Tina. There is an information against Raven in the record that probably has her date of birth. I don't know what it is
Just
offhand.
generally is.
They're older. I don't know actually. I would guess maybe 5 years or so. I don't think that they were substantially older. They began living with Mr. Blackwing, I think both of them when they were underaged.
Okay.
So I don't think it probably is more than 5 years, but that's, I could be wrong about that. It might be as much as 10, but at least as to Raven, I think her age you can find in the record.
Okay, thank you.
Okay. If there are no further questions, we would ask this court to reverse.
Thank you very much. We appreciate the briefing and the arguments in this matter. We'll take it under advisement.